Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion in TANDON versus NEWSOM, Governor of California, on application for injunctive relief, April 9th, 2021. It's a per curiam opinion, full opinion, but only 4 pages, so we're just going to go ahead and read it. If you'd like to support the podcast, please stay tuned in the end of the podcast. The application for injunctive relief presented to Justice Kagan, and by her referred to the court, is granted pending disposition of the appeal in the United States Court of Appeals for the Ninth Circuit and disposition of the petition for writ of certiorari, if such writ is timely sought. Should the petition for a writ of certiorari be denied, this order shall terminate automatically. In the event the petition for a writ of certiorari is granted, the order shall terminate upon the sending down of the judgment of this court. The Ninth Circuit's failure to grant an injunction pending appeal was erroneous. This court's decisions have made the following points clear. First, government regulations are not neutral and generally applicable, and therefore trigger strict scrutiny under the Free Exercise Clause whenever they treat any comparable secular activity more favorably than religious exercise. That's Roman Catholic Diocese of Brooklyn versus Cuomo, and there's going to be a bunch of concurring opinion quotes coming up. It is no answer that a state treats some comparable secular businesses or other activities as poorly or even less favorably than the religious exercise at issue. That's Kavanaugh. Second, whether two activities are comparable for purposes of free exercise clause must be judged against the asserted government interest that justifies the regulation at issue. That's the per curiam from that one. Describing secular activities treated more favorably than religious worship that either have contributed to the spread of COVID-19 or could have presented similar risks. Comparability is concerned with the risks various activities pose, not the reasons why people gather. That's Gorsuch's concurring opinion. Third, the government has the burden to establish that the challenged law satisfies strict scrutiny. To do so in this context, it must do more than assert that certain risk factors are always present in worship or always absent from other secular activities. The government may allow, always absent from other secular activities the government may allow. That's quoting South Bay United Pentecostal Church versus NEWSOM, a statement of Justice Gorsuch and Justice Barrett concurring. Instead, narrow tailoring requires the government to show that measures less restrictive of the First Amendment activity could not address its interest in reducing the spread of COVID. Where the government permits other activities to proceed with precautions, it must show that the religious exercise at issue is more dangerous than those activities, even when the same precautions are applied. Otherwise, precautions that suffice for other activities suffice for religious exercise too. It's Roman Catholic Diocese again, and South Bay, and statement of Justice Gorsuch. Fourth, even if the government withdraws or modifies a COVID restriction in the course of litigation, that does not necessarily moot the case. And so long as a case is not moot, litigants otherwise entitled to emergency injunctive relief remain entitled to such relief where the applicants remain under a constant threat that government officials will use their power to reinstate the challenged restrictions. Roman Catholic Diocese again. See also High Plains Harvest Church versus Polis. These principles dictated the outcome in this case, as they did in Gateway City Church versus NEWSOM. First, California treats some comparable secular activities more favorable than at-home religious exercise, permitting hair salons, retail stores, personal care services, movie theaters, private suites at sporting events and concerts, and indoor restaurants to bring together more than 3 households at a time. That's the application to emergency application for writ of injunction. Second, the Ninth Circuit did not conclude that those activities pose a lesser risk of transmission than applicants' proposed religious exercise at home. The Ninth Circuit erroneously rejected these comparators simply because this court's previous decisions involve public buildings as opposed to private buildings, TANDON versus NEWSOM. Third, instead of requiring the state to explain why it could not safely permit at-home worshipers to gather in larger numbers while using precautions used in secular activities, the Ninth Circuit erroneously declared that such measures might not translate readily to the home. The state cannot assume the worst when people go to worship, but assume the best when people go to work. It's Roberts versus Nace. And fourth, although California officials changed the challenge policy shortly after this application was filed, the previous restrictions remain in place until April 15th. And officials with a track record of moving the goalposts retain authority to reinstate those heightened restrictions at any time. It's a South Bay Again statement of Gorsuch. Applicants are likely to succeed on the merits of their free exercise claim. They are irreparably harmed by the loss of free exercise rights for even minimal periods of time, and the state has not shown that public health would be imperiled by employing less restrictive measures. Roman Catholic Diocese again. Accordingly, applicants are entitled to an injunction pending appeal. This is the fifth time the court has summarily rejected the Ninth Circuit's analysis of California's COVID restrictions on religious exercise. See Harvest Rock Church versus Newsom, South Bay, Gish versus Newsom, Gateway City. It is unsurprising that such litigants are entitled to relief. California's blueprint system contains myriad exceptions and accommodations for comparable activities, thus requiring the application of strict scrutiny. And historically, strict scrutiny requires the state to further interests of the highest order by means narrowly tailored in the pursuit of those interests. That's a Church of Lukemi Babaluai versus Hyela, internal quotation marks admitted. That standard is not watered down. It really means what it says. The Chief Justice would deny the application. And again, that was a per curiam opinion. So if you'd like to get a hold of the podcast, I can be reached at rhodesscholar80@gmail.com. That's ROADS and the number 80. And if you'd like to support the podcast or support me as I work my way through law school, please find the podcast on Patreon or follow the PayPal link in the show notes.